We thank you so much, Rich and I and the Doctors Company, for joining us tonight to hear our story on will your documentation defend you in 2023? And I think that you know that documentation is everything. And if it wasn't documented, the courts may question, was it done? So I think you'll get some good insights tonight. I will remind you that we are offering continuing medical education for you tonight. If you are a PA or an NP, the PA board and the nursing boards accept our CME credit certification for continuing education. You have until 5 p.m. on March 22nd to claim credit. If you have a smartphone, you can hold your camera on, put your camera on, hold it up to scan that QR code right here in the center, and it will say check in, and you will put your name. This screen comes up, your name, your first and last name, your licenses, if you're an MD, a DO, a PA, RN, NP, and your affiliation can just be the name of your group, or if you're Dr. Smith medical group, just put Dr. Smith, that's all. And then hit check in, and in 1 hour, when you check in again on the screen, you will see that it says complete the evaluation. I am the Senior Patient Safety Risk Manager with the Doctors Company, and we are very honored to be affiliated with San Diego County Medical Society. And I would encourage you to check their website for all of the activities and resources that they offer. We believe that partnering with the medical societies is a great way to introduce you to education. You do not have to be a TDC insured to ever attend any of our programs, and we thank you for being with us tonight. I'm not going to go through our bios, although I will say a few words of introduction for my illustrious co-speaker tonight, Richard Cahill. He is our Vice President and Associate General Counsel with a very distinguished career of over 35 years as a malpractice defense attorney, as a corporate attorney, and he has been with our company. I think he's going on his 16th or 17th year with the Doctors Company, and he supports the patient safety department as well as handles many things in the legal department for appeals and all kinds of things. And I'd be lost without him. I love to have him co-present with me. He also is a prolific author and writer. You can find his articles on our website. The objectives tonight are, again, I'm not going to read every slide, but the big thing is to recognize that documentation outside the EHR may pose a risk for your practice. That's the one that's really important that you're going to hear about tonight. And accessing your documentation practices for areas to improve, and you'll hear about that tonight. I always like to start with a quote from someone that inspires me when I'm preparing the research on a program. And this Anais Nin struck me when I read, "We write to taste life twice, in the moment and in retrospect." And it really dawned on me, that's what the medical record is, tasting life twice. You record at the time of the visit, but it will be used in retrospect as your silent witness. It's a communication tool to show who does what when. It documents outcome, aftercare instructions, and it also talks about the plan you have for the patient. So what is the value of documentation? Well, I think that's not lost on you. First of all, it helps patient and family understand care. Now they have access through the portal on electronic record. If you don't use an electronic health record, they have full rights to request a copy of their medical records, but it supports the billing. That's your money. It's used for peer review activities in your group and in hospitals. There are many audits done by healthcare plans, promotes continuity of care, and of course, the most important one, I think, is that it defends your good care and your good treatment. It documents a patient's continuing health care in response to treatment. It is a legal document. It's used in lawsuits. It's also used for education, research, statistical tracking and evaluation. And it definitely is used to assess the quality of healthcare services delivered through a quality improvement or quality assurance function. One of the things that I think I run into more than anything else, because in patient safety, I get calls, well, if you're getting sued, it's going to be turned over to the claims department. I get the call when people get a letter from the medical board or a grievance letter from the healthcare plan. And that's where the medical record is a key element of the rebuttal that we have our attorney write, because we assign an attorney to respond on these for the doctors. It's not a claim against your account. It doesn't increase your premium. It's under our Medigard coverage. And so having good documentation to incorporate into the rebuttal to complaints to medical board and health plan grievances is really important. By the way, lack of documentation or the wrong documentation is the most cited reason for non-payment by a third party. This pretty much restates what I've already said, so I just want to emphasize that the consequences of poor documentation can be a misinterpretation of your care. It can be harm to the patient, because if the next clinician who comes along reads your documentation and doesn't know what happened, they might miss something important. Rich and I did a program a couple years ago when we were still able to do things in person, and I'll never forget they always wait at the end to ask us questions, and the doctor came up, he said, "Can I talk to you in private?" And I said, "Sure." And we did a program on documentation. He said, "I'm concerned about what I heard you say today. I'm a neurologist, which is a specialist, and sometimes I don't get my notes in for 3 or 4 months." And I said, "That's a big problem. You can't do that." And he was part of a multi-specialty group. I said, "That means if I'm a patient and I come in and get an assessment by you, nobody else in your group will even know what you did for me 3-4 months earlier." He said, "That's right." I said, that could cause serious problem for the patient. You have to change that. Let's talk about what we could do." And ultimately, I met with the group and we got him a scribe, and everybody lived happily ever after. So who wrote this? I do a lot of medical record review, and I wanted to share some things, and it's out of, I don't ever identify the type of practice, but these are actual lines that I saw doing medical record review in the last year. "This patient is ridiculous and I will not see him again." Now, the doctor wrote that in a task note in an EHR. "Please do not schedule this patient for me in the future. She is nuts and causes a problem every time she comes in the office." Again, the doctor wrote that to the front desk in a task note. Then somebody at the front desk wrote in a task note to a doctor, "Why do you continue to see this mean and obnoxious patient?" These were all different patients and different doctors, by the way. Here's the front desk said, "You said you would never see this patient again. What happened to that?" Then the receptionist sent a note to the doctor in the task note that said, "Your crabby patient is here today to see you." Those are not good comments. Those are subjective, inappropriate, and unprofessional comments. And that's a problem. And we don't want to see those in the record. And one of the reasons you don't want to see these in the record is October 6th, 2022, one of the final rules for the 21st Century Cures Act, which gave you open notes in April of 2021, stipulated that unblocking applied to everything in the record, including task notes, unless it met the few exceptions that are in the Cures law. And those are primarily for psychiatrists, and if the patient saw the note, they would be really upset. And I want to tell you that who wrote these statements, patients went in their medical records and they saw these statements, and they filed complaints with their health plan and or the medical board. And that's why you want to be sure that anything you or your staff put in a task note, write it as though the patient is looking over your shoulder when it's written. Now, I do want to tell you the top 10 findings in medical record reviews, and I've reviewed thousands of records. And many of these, by the way, are related to documentation that your MA should be doing. Allergy reaction, not consistently documented. What I see most often is it says, if there's no known allergy, you're done. But if they have an allergy to something, what was the reaction? Was it hives, swelling, nausea, shortness of breath? In EHRs, there's a drop down. So it's very easy, you mark it. I always marvel at how nobody drops it down. So I want you to be sure that you know to be complete, it has to have the reaction. Medication reconciliation, I also find, rarely comments on over-the-counter meds, recreational, cannabis. Cannabis is legal now in California, and it could be patient declines cannabis use or patient uses recreational cannabis gummies. You want to know that because you might prescribe something that would be contraindicated. It's not illegal to use cannabis. There's nothing bad about that. Homeopathic supplements, herbs. Chia seeds are contraindicated to take with any cardiac medication. There's been a black box warning on the meds by the FDA. So if you're not checking on herbs and over the, supplements and things people are taking, if there was something that happened and they had a heart attack, Rich, I'm going to ask you to chime in on this. So if I'm the patient and I was never asked if I use chia seeds, and then because chia seeds will make life better, you'll sleep better, you'll lose weight, you'll look younger, you'll be smarter. I mean, the commercials are out of control. And then I'm taking a cardiac medication and I die and my family sues and the attorney finds that it was contraindicated. Is there any implication for my doctor who did or didn't advise me?
The problem is always that they will bring out the black box warning and they'll say, were you aware of this from the package insert? Sometimes the physician is aware of it and sometimes not. But the problem is that once it becomes a black box warning, you're on notice that you need to do something or inquire about it. And as you mentioned at the outset of the program, if it's not recorded, it'll be generally interpreted as not having been done. Even though you can say, well, it's my habit and practice and so forth. If it's not notated, the assumption will be that no question was asked, and invariably they'll bring in an independent expert who will testify that the standard of care required you to ask about medication reconciliation, over-the-counter, recreational, and so forth. So that can be problematic in trying to defend a professional liability case. Similarly, with inquiries and complaints to the state medical board, the medical board will ask those same questions, and if they don't see positive information about the chart, it tends to have a negative inference.
Thank you, Rich. Social history limited. I see this all the time. Patient declines smoking or patient stopped smoking 20 years ago, but nothing about vaping, no mention of alcohol use, or patient uses limited alcohol. That doesn't mean anything. The question is how much alcohol? 1 to 2 glasses a week, a bottle a week. No documentation of a chaperone present. This is really a big one missing. Family or guest is not appropriate to chaperone, and the chaperone needs to be in the room and it should be documented. And if it's you can have your MA step in, and if I'm the MA, you could put MAKS present for chaperone. While you're doing that intimate exam, if you're examining any intimate body parts below the waist, above the waist, they're just there for that and then they leave. If you do not document a chaperone and you had one, it could be several years later when you're in litigation and you're not going to remember. And if you say, well, we always had a chaperone, I just didn't document at that time. I also recommend that if your MA is going to be the chaperone, you tell the MA to document MA present to chaperone physical exam. If a patient says, I don't want a chaperone in the room, then you have the right to say, I understand that. Our policy is to have a chaperone in the room. She or he will just be in for the moment. And the question I get from doctors is, do they have to be watching, be able to see my hands all the time? And the answer is no, there's no rule that says they have to be able to see your hands. And sometimes people say, I don't want a male or I don't want a female, and you can't always accommodate that, but their family member does not qualify. You can ask your office manager to come in. More medical record review findings. No documentation of the language used if not English. So many of you are incredibly versatile in your languages and you are multilingual. So if I speak Chinese and I'm the patient and I come and you speak Chinese and you conduct the patient visit in Chinese, you need to document, patient discussion in Chinese. Because what happens when we get into litigation and nothing's there, and the patient's asked a question, they say, I don't know, the doctor spoke English, I only speak Chinese, there was no translator. So this is where, where's your comeback? Well, I did it in Chinese. So your MA can document that it was in Chinese or whatever language it was. No documentation related to checking cures when necessary. I'm not going to go off on this, and don't be confused with the cures, 21st century cures that relates to open notes, because this is the California utilization review and evaluation system for prescription management in California. And so there's very specific what for scheduled 2 and 3 drugs, you have to check cures for the first time you prescribe and when you do a refill within 90 days. If a patient's on hospice, you do not have to check cures at all, by the way. Informed consent documentation issues. When I look at consents, and I'm not going to get real detailed in this conversation, but the consent is signed and witnessed by, I see a medical assistant. I see no physician's signature, no comment in the medical record about a consent. What I most often see is the operative report opens with, after obtaining informed consent, which is dictated after the procedure is over. Rich, how's that going to play in court on the electronic courtroom when our only information about obtaining consent is after this procedure is over?
It becomes very problematic, and it's important that it be documented, and it can be documented very simply. I did a recent article on that over the last couple of weeks that says informed consent is important. It's important to document that the patient was told what his or her condition was, the options of treatment, including the risks and benefits associated with each, including the risks associated with not doing any type of therapy. And if a patient chooses, as he or she is entitled to do under the law, not to have any type of procedure done, then that needs to be documented, and an adequate informed refusal needs to show that the patient was informed as to what the consequences may be of not having any treatment at all. Because a patient, and the law has been clear since 1917 in a famous New York case, that patients have a right of self-determination. And if they choose to exercise that right and there are adverse consequences as a result of their decision, then the physician will not be held liable for that.
Thank you. This slide talks about documentation that I don't see about patient education. Reference to texts and emails are documented. I'll see texted with patient about something, but then I look in the record and it's not there. If you're texting or emailing with a patient, those texts and emails, first of all, should be only on an encrypted text phone and on an encrypted computer, but you also have to print and scan those texts and emails into the medical record. And so if you're not doing that, you're leaving out important information, which would be found in the case of litigation, because all of those texts and emails will be in metadata on the person's phone or on their computer, and it can be used to support you, and it could be used against you. So again, texting and emailing needs to be in the record. And I'll just put a thought here in your mind: reduce your number of texts and emails with patients, because it's very busy work for your staff to have to print all that off and scan it in. No clinical summary provided to the patient. If you have an EHR, most all of them have a clinical summary. And I look and I see when I'm reviewing, no clinical summary given to the patient. And then the doctor has written patient declined clinical summary. Well, I think if you said, Rich, do you want your clinical summary? I can't see you declining it. I know people that went to their doctor and I said, did you get a clinical summary? And they said, no, they didn't even tell me there was one. And I said, well, why don't you ask? And they called, and I had somebody who called me and said, I looked in my portal in the medical record and it said I declined. I didn't decline. They never told me I could have it. So that's an issue that I see. What not to document: subjective comments about patient behavior and appearance. We don't want long self-defensive entries to explain something. Please no pointing at third parties, no arguing with patient in portal exchanges. Sometimes I see messages between office staff and patients that looks antagonistic. That isn't the way we do business. We don't do business by text and email. I know the millennials and young people love to text and email. It's a pick up the phone and call the patient, tell your staff that. And of course, you cannot engage with anyone not HIPAA authorized by the patient. If someone comes with the patient to the visit, that is implied consent, and you can say whatever in front of that person. When that person leaves and calls the office later and wants the test results or wants to talk to you, your staff has to verify if the patient signed a release, because if they didn't, there's no consent. It's only implied in the office. Once the patient leaves the office and that person leaves, there's no consent. And I talked already about encryption. If you are doing email and texting or voicemail with the patient, the doctor's company created a sample consent if you don't have encryption. This is a consent to leave voicemail or text messages, and you can use this. You can call it anything you want and use that as an example. We also have a consent for online communications that says that you understand that you're using unencrypted, like if you are using an email on Gmail, or you're sending me something to my Gmail account's not encrypted, then you would want me to sign this online communication form that says, I understand that anything that we exchange on the internet is available to anybody who goes into the dark web. With that, I'm going to turn it over to Rich to talk about your ethical obligation and the medical record. And Rich, we're going to start with the physician's obligation.
Thank you, Kathleen. Good evening, everyone. My name is Richard Cahill. I'm Vice President and Associate General Counsel with the Doctors Company. I've spent more than 35 years in defending the healthcare community, physicians, hospitals, and various advanced practice providers in a variety of different forums. My principal clients in private practice included Cigna Health Plans, Kaiser Permanente, and Tenet Health Systems. So what is the physician's obligation? Principally, these are set out in federal and state privacy laws. In California, we have the Confidentiality of Medical Information Act, which is contained in Civil Code Section 56. Also, we have HIPAA, and I think you need to be aware that these are the 4 ethical priorities. Number 1, privacy and confidentiality. Security breaches are very important to avoid. If they occur, it may well be that the Office of Civil Rights under the United States Department of Justice will conduct an investigation that has some very serious adverse consequences. Also, it's important to have system implementation in your practice to show that what you did comported with federal and state law, and that you periodically evaluated and did audits to make sure that you were current and that any issues were appropriately addressed. Also, data inaccuracies. And now that we have the Cures Act of the 21st century in effect, it's important because patients can access their portal, can review what was written, and can make a variety of requests that changes be made. So it's important that you're aware of your obligations. And here's the ethics manual from the American College of Physicians. First of all, effective communication is critical to a strong patient-physician relationship. One of the leading problems that we see when we do our closed claims studies is that because of some communication issue between the patient and the physician, between various treating physicians, or otherwise, that creates a problem, and the miscommunication is continued and creates conflicts within the patient record. Also, communication through email or other electronic means can supplement in-person encounters, but it must, as Kathleen mentioned, be done under appropriate guidelines. And if you're going to be using various forms of communication other than in-person, you need to make sure the patient understands it, accepts it, and indicates that it's appropriate to use that form of communication. They should only be used by physicians in an established relationship and with patient consent. It's important to realize that the physician-patient relationship is the first key in a professional liability action. Patients must establish to a reasonable medical probability that there was a doctor-patient relationship before they're able to establish liability or any other element. And also there are a couple of outliers, one of which is curbside consultations, which you need to be very careful about. I recently published an article on this, and I recommend it to your reading because those are very critical issues that As a referring physician, you may notate what the consultant said, but the consulting physician had absolutely no record or recollection of the event several years down the line. Also, there's a question when the relationship terminates. Is it in fact over? Was the patient advised that the relationship was over? Or is there a miscommunication in which the patient can conclude that I should have been notified of this, that there was inadequate documentation, and so forth? They should be in the patient's medical record. Anytime that there's a communication with the patient, and sometimes it's difficult, particularly if you get after hours calls, but make sure that something is notated in the patient's record, because when the case comes to trial or arbitration 3 to 5 years later, you'll have no independent recollection. And as Kathleen mentioned at the outset, if it's not recorded, there is a tendency for a plaintiff's attorney to argue and for a jury to determine if it's not recorded, it wasn't done. So who actually reviews this? When I first started doing professional liability defense in the early 1980s, about the only people that reviewed the records were other physicians. Occasionally, you'd get a circumstance where a patient's attorney would be contacted, would review the records to decide whether or not to take the case. But now there's a whole plethora of individuals and entities that will review it. First of all, patient and family can review it through the portal. Other physicians will see it either because they're treating physicians, third-party payers, and this includes CMS, and private payers such as Cigna, Anthem Blue Cross, and so forth. Also, regulatory agents see this, and that would include the California Medical Board. I frequently get questions from practices where they will ask, well, gee, the medical board wants to see these records, but I don't have a HIPAA compliant authorization, no court order, and no subpoena. As a government oversight agency, the medical board is entitled to see those records, whether or not the patient consents to it or not. Also, that would include the Office of Civil Rights under the United States Department of Justice. If these various regulatory agencies want the records, they can get them without having to do a subpoena. Attorneys frequently will review these records, and I review these requests on behalf of the company nationwide. The attorneys may want them on behalf of a patient, but they may want them for other unrelated issues such as motor vehicle accidents, workers' compensation claims, SSDI matters, life insurance, and so forth. So the attorneys may be reviewing them for reasons other than for which the record was created. Also, independent experts. And as we've discussed in other programs, another issue that the plaintiffs have to establish in a professional liability case is that, one, was there a duty of due care? And that's determined by independent experts who will say, I have education similar to the individual involved here. I'm familiar with the types of circumstances, and I believe that the care was or was not consistent with the community standard. That then, as Kathleen mentioned, is frequently put on the electronic courtroom where everyone views a monitor, sees the record, and the independent expert will testify as to why the record was or was not appropriate. And in that circumstances, juries frequently have an opportunity to review those documents during the course of their deliberations. So it's very powerful evidence and can be reviewed throughout various forms of civil litigation. Keep in mind, we're in an era of discovery. When I first started practicing in professional liability, a new statute had come into effect. It was called the New Discovery Act of 1986. Well, we're nearly 40 years past that, and it's an age of discoverability. What will happen is the question will be, was the information that was sought either through interrogatories, deposition testimony, subpoenas, or record requests reasonably calculated to lead to the discovery of admissible evidence? It's a very, very broad standard. And most states have that type of a standard. I had one recently in which an attorney in Atlanta wanted to see documentation. We looked at the statute with local counsel and came to the conclusion that because it was such a broad statute, consistent with what's common throughout the United States, they were entitled to that, although there were some limitations in which we felt it was appropriate to object. Keep in mind, most lawyers do not have a scientific background. For example, I specialized in medieval English history. Many of my colleagues have similar backgrounds in which they studied economics, political science, or otherwise. But we all, at the outset of litigation, will do two things. Number one, get a copy of the records, and two, retain independent IT experts who will take a look at the metadata and uncover all information that the media may demonstrate. Now, as I'd indicated, the definition of a medical record has expanded since the advent of the electronic health system. And great latitude is given to attorneys when they're trying to find out what happened and why, and by whom and when. Rules to follow. Keep in mind that every keystroke, click, tap, and voice recognition are discoverable and may help the patient, may be advantageous to the practitioner. It's my experience, and having done this type of defense for more than 35 years, the medical record is your silent witness and helps to demonstrate that what you did was timely, medically necessary, appropriately provided, and supported your plan of care. So keep in mind that the medical record is key, and that you should be succinct but as complete as possible under the circumstances. Because once something is entered in the electronic health record, metadata is forever, and they can see who is in the record, for how long, and what they did. And the audit trail follows you. And keep in mind, it tells what was done at all times. And this should include mobile phone calls and messages, texting messages, and posts on physician rating sites. And this is something we see frequently. More often than not, an aggravated patient may not send you a letter, may not file a complaint with the medical board, although in California that's very easy to do. They simply go to social media and enter negative adverse posts. And it's very difficult when dealing with those to make sure that you do not violate federal law such as HIPAA or state law, the Confidentiality of Medical Information Act. And we have information on our website to tell you how to deal with those to make sure that you're consistent with federal and state law, but also to the extent possible can protect your own interests. Even if you delete the text, call, or message, once an IT expert takes a look at the metadata, he or she will be able to determine whether something was deleted or amended at a later time and appropriately identified as a late entry or as an addenda. There are a number of landmines that you should consider when working with the EHR. Avoid copy and paste. That can be an advantageous way of quickly putting information in, but frequently copy and paste simply takes old information and re-enters it as current and accurate, which may not necessarily be the case given the current clinical presentation. Also, do not share your password with anyone. We've seen a number of circumstances where individuals shared their password for no reasonable reason. And unfortunately, what happens is somebody gets in there, information is breached, and then we get inquiries from the Office of Civil Rights that there was an improper data breach. Some of you may remember several years ago at my alma mater, UCLA, there was a couple of people in the records department that were seeking information from the Ronald Reagan Medical Center because they were curious about celebrities and their families. Do not share your password with anyone. Also, be very careful not to enter incorrect information, and make sure when you're entering it, you're in the correct patient's chart. Also, as Kathleen stressed, administrative tasks are now part of the medical record, and because of the Cures Act of the 21st century, which went into effect 2 years ago at this time, patients are able to get all of that. And I have, Kathleen and I did 4 articles on this about a year and a half ago on the Cures Act, what constitutes a blocking of information and so forth. And if you have questions about that, I commend those 4 articles to your reading. As I'd indicated, all social media is discoverable. And there has been issues where various social media giants are refusing to honor subpoenas. People are very aggressive. They go into court. They try to get that. But ultimately, it is discoverable. And if you have somebody, and frequently our defense attorneys will go onto social media sites to try to determine what information a patient may have entered. Keep in mind, plaintiffs' attorneys do that as well. They go onto social media sites and they're able to identify what a particular practitioner may have done. Kathleen, would you spend a moment and talk about Google Alerts?
Yes, one of the most important things you can do is have a Google alert set with your name and with the name of your practice. And to do that, it's free. You have to set up a Gmail account. And so you set up a Richard Cahill at Gmail, and then you go on into the Google search box and put set alert, and it will tell you, here's where you set it up. It says, what do you want to set alert? And I put Richard Cahill. I wouldn't put Richard Cahill, MD. I would put Dr. Richard Cahill, because that's how people do it. But you can set 2 or 3 alerts. If there's a ABC medical group, you could set it ABC medical group. So you might set 2 or 3 for the practice. I recommend that you set up a Google Gmail address that is just for this purpose. So you don't get mail in your regular Gmail account. You set up a new one, or have your office manager set it up and put the alert in. And then the alert, the choices are, when do you want it? As it happens. There's a drop down box. As it happens, in the US only. And every time your name or the name of your group is posted somewhere on the internet, then that Gmail account gets an email, and you can have your office manager review that. I have so many stories I could tell about encouraging physicians to set up the alert and how many calls I've gotten. And I'll just give you a couple of examples. I thought the one that was most compelling was a doctor in Orange County called me and said, I'm so glad I set the alert up. It was a Thursday night. And he said, I set it up on Friday. On Saturday, I found out that there's a doctor. This doctor was in Orange County. He said, there's a doctor using my medical license in Van Nuys, and he has a practice. And he is using my medical license number, and he's been doing it for 4 years. Of course, I said, you got to call the police, report to the medical board and everything. And I've had several doctors say they found people using their name. And then I have doctors who called and said, I found out my husband is on Ashley Madison dating website, or I found out, I mean, you can set it up. I set it up for my teenage grandsons, okay, because I want to know, what are they doing? If I told them, I'll find you if you're on the internet doing something you shouldn't be. So a Google alert is a good thing to set up, and you can set up an unlimited number of accounts. I just recommend you set up for your practice and for in your name, Dr. Joe Blow. You could put Joe Blow, MD. But what we find is when people post on social media, or when they post something, they tend to do it as Dr. whatever. So that's the thing that I wanted to say about Gmail. And I want to say, if you didn't catch in the news this week, that several government agencies are now, that provide a cell phone to their staff, will not allow them any longer to have TikTok on that phone, because they have found that TikTok originates out of China, that they can infiltrate your system through that cell phone. I thought that was pretty fascinating. Okay, Rich, how about let's do some case studies.
Thank you, Kathleen. Very briefly, so that we have a framework to understand professional liability claims. And a professional liability claim, and this gives us a little bit of a background and a structure when we talk about our case studies. Number one, the plaintiff has to establish that there was a doctor-patient relationship. If there wasn't, that's the end of the case. But if there is, the physician is required to provide care consistent with what other similarly trained practitioners would have done under same or similar circumstance. Failure to do so constitutes a violation of the standard of care, and that is ordinarily established by independent expert testimony. In my experience over the last 35 years, plaintiffs' attorneys frequently will go to academic medical centers to retain their experts, and of course they're excellent. But my experience has been that by retaining experts who are familiar with the community standard, that work in the community environment, that jurors tend to find that more persuasive. Number three, did the violation of the standard of care to a reasonable degree of medical probability cause a compensable injury to the patient? And if that medical probability, more likely than not, is not met, the defense will prevail. And finally, compensable injuries. In California, they generally fall into two categories: general, non-economic damages, pain, suffering, life isn't as good as it used to be, and so forth. And of course, many of you are probably familiar that the micro legislation from the mid-1970s was amended last year, and that the non-economic damages has gone up from $250,000, effective the first of this year. And finally, economic damages, and these are out-of-pocket expenses, past, present, and future, such as loss of earnings or earning capacity, expenses associated with medical care, past, present, and future. So these are the background issues that we have to take in mind as we're reviewing our case studies. Our first case study involves a child who was brought to urgent care with a fever. Blood cultures were obtained, and the patient was admitted for further workup. On day 3 of the hospitalization, the child was discharged. At that point, according to the clinic records and the hospital records, the patient was afebrile. And at that point, the preliminary blood cultures were negative for growth. Unfortunately, the final blood cultures came back following discharge and were positive for bacterial growth. The results were communicated to the emergency department, which was appropriate, but it does not appear, at least according to the medical records, that that information was reported to the primary care physician to follow up following discharge. 3 days later, the patient presented to a pediatric clinic with a fever. Released at that visit because the patient was afebrile. No one bothered to check the EHR, unclear whether they had access or they simply didn't follow up. 2 days later, the patient again presents with a fever, and now the EHR was reviewed and the positive blood cultures from several days prior were identified. Unfortunately, the child succumbed to infection several days later. Nothing could have been done to save the child's life. So what did the independent experts say on both sides, both plaintiff and defense? Number one, the physician should have reviewed the available test results. And at this point, it became evident, according to the discovery, that those would have been available had they been checked. It was discharged prior to validating the final blood culture results. According to the independent experts, those results should have been checked prior to the time the patient was actually discharged. And they were not reviewed during the clinic visit. I apologize if you hear some background noise. Apparently, we're doing an end of the day cycle, and I'm getting some interference. Also, the test results were not provided to the child's pediatrician. And that, according to the independent experts, constituted a breach of the community standard. Let's take a look now at a second case study involving an electronic health records glitch. In this particular case, the electronic health record was recently upgraded by the practice. The patient was seen in specialty medical practice, and the chief complaint at the time of initial presentation was of tongue irritation. Diagnostic tests were performed, and they showed a positive for malignancy. The lesion was excised appropriately and in a timely manner. But unfortunately, the symptoms persisted following the excision and during subsequent clinic visits. An additional lesion was defined according to the clinic records, although it was unclear whether or not that was actually biopsied. It was defined as benign. Follow-up office visits occurred, but unfortunately, a subsequent pathology report showed that there was a malignancy. That was unfortunately not reviewed or scanned into the electronic health record so that the clinicians were aware of the change in circumstances. Sadly, several months later, the patient died of the disease. So what did the experts in this circumstance say? They were critical. There was no follow-up on the pathology report. It had not been scanned into the EHR, and clearly that was a glitch. One of the things that I found over the years is that the defense wins a significant percentage of our cases, somewhere between 75 and 80% of the cases. There's a very strong preference in favor of practitioners that what was done for the right reason and consistent with the community standard. Where I find that jurors tend to be critical of healthcare providers is where there is a systems failure. And in this case, there was a systems failure because the critical piece of information in the pathology report never made its way into EHR. It should have been scanned and was not. So who is checking to see if the patient is caring for the patient, whether or not that individual sees the report? So our recommendation is to assign staff to monitor and ensure that all data is in the electronic health record, particularly if different formats such as scanning of documentation is being used, and that the physician responsible for the patient's care is aware if there are abnormal findings contained in any type of data. Ignorance of medical information is not a defense. What tends to happen is, although there's a strong preference supporting healthcare providers, is that there was a systems failure, and that had that not occurred, the practitioner invariably is assumed to have made the appropriate diagnosis and that better results would have occurred. When there's a systems failure, it's very difficult for the defense to try to support that. And remember, as you're doing documentation, document your thought process. If you have entertained a differential diagnosis, indicate that. It doesn't have to be long and detailed, just your basic thoughts, as long as you also include the recommendations. It's important to indicate in the notes what the response was by the patient to the treatment. Frequently, we will see that there is reference to patient education, but make sure that's documented. If you give follow-up care instructions or you provide information in the form of documentation to a patient, I recommend that you also put that in the chart. Invariably, patients don't remember at some later date, and they'll say, no, I wasn't given anything. If the record is documented that the patient was given documents X, Y, and Z, or actual copies of those are included within the medical records, it's much easier to defend because, as Kathleen indicated, if it's documented, the strong preference is that it was in fact done. A couple of quick strategies to reduce risks on various documentation landmines that we've identified this evening. Follow the EHR guidelines to make sure that proper documentation is done at or near the time of the event. Because if it's done at or near the time of the event, it's presumed that it was done and that it was valid. Read your documentation before you sign off on it to make sure that it's, one, accurate, and two, that it makes sense. Consider a medical record audit periodically to make sure that what you're hoping is being captured in the records is in fact being captured. And if you find that there are discrepancies between what your internal policy is and what's actually being found on audit, make sure that those are corrected. Periodically, your policies and procedures need to be updated to make sure that you're consistent with the standard of care. Also, use only approved abbreviations. Sometimes individuals use personal abbreviations. Sometimes within areas of specialties, they use abbreviations that perhaps other practitioners in other practices or in other areas of specialty may not be familiar with. When I first started doing this work in the early 1980s, occasionally I would see abbreviations in the chart when there was a catastrophic result to a child following a delivery that would say GORC. And it had a negative connotation just by the sound of the word, but what it meant was it was an acronym, God only really knows. That had a very negative effect in cases because, like I'd indicated, jurors tend to support very strongly what healthcare providers do, but if they result to a deity and say, God only really knows, it tends to have a negative effect. Fortunately, I haven't seen that in many decades. As I indicated at the outset, avoid copying and pasting. Although it's a quick way to get information into the record, frequently it brings information in that is dated and may no longer be either applicable or accurate. And finally, a very key thing to remember is metadata is forever and cannot be changed, or permanently deleted. Kathleen, thank you. I think that concludes my portion of the program.
Thank you, Rich. We're going to be right back with you in a moment, though, with some questions. I want to just comment on developing and advancing good patient rapport. Patients love you. You have studied hard to be a physician. You provide great care. Remember to engage in active listening. Let your patients talk for 90 seconds before you interrupt them. Ask open-ended questions. Of course, all of the patient engagement research shows that patients have the best experience if you're sitting at their level, sit in a chair, and you're looking at them, use eye contact, nod appropriately, don't cross your arms, don't stick your hands in your pockets, don't jingle change, don't look at your watch, don't look at your phone, look at them. And ask them and use their name. Repeat back to what you hear them say to can be sure you're getting the same message. And of course, the important thing is when you're giving patients new information, how are you checking with them to be sure they got it? Ask them to repeat back. You said, you know, today I diagnosed you that you have elevated blood pressure, and there's several really important things we want to do. And the first, many times, if you, let's say you're going to say 3 things, and you say, the first thing I want you to do is number 1, I want you to take salt out of your diet. Number 2, I want you to take this medication. And number 3, I want you to measure your blood pressure. And the most important thing is measure your blood pressure, whatever it is. The research shows that number 3 is what they remember least. So tell them the most important thing first. The most important thing I want you to do, I'm going to go over 3 things, and the most important one first, and then I'm going to ask you to go over them with me. That's called telling the patient to listen for repeat. If you have children, teenagers, or toddlers, you have to do this. Say, I'm going to give you instructions about what time you have to be in, and I want you to listen carefully, so I want you to repeat it back to me. That's what we do when we want to be sure they got the message. Now, the next thing I'm going to tell you about is, in order to get CME credit, I have to include content that meets the California law that says we give content on cultural competence, linguistic competence, and implicit bias. I put these slides in. I'm not going to go over them, but I did want to comment on 2 things that I mentioned earlier about a chaperone, that you need to document if a chaperone is present, and that you document what language you use, and document if a translator is present. And a family member is not appropriate as a translator either. And then, of course, document the language you use. You have access to get a copy of these slides from San Diego County. And my favorite slide is the last one. I hear and I forget. I see and I remember. I do and I understand. Confucius, look at, in the BC period, he was that thoughtful. Now, Paul, what I'd like to do is jump to the chat and ask if there are any questions. Yes. And if there aren't, or if there are, we'll take the questions. Let's go.
I've got like 10 lined up, some fast, some a little more. Can you please put the CME slide up? Because that was your request.
The CME slide. You want credit? Bring your camera up on your cell phone and put it on. Don't take a picture. Hold it and scan it. It'll bring up the site. You can also type doctors.cnf.io up in the top of your screen where the URL is, and it will take you to the site. Okay, let's hear the questions,
okay.
Paul.
Really quick, what is a task note? You had some examples at the beginning of this patient is rude or something like that. You said they were in task notes. What is a task note?
A task note is found in most electronic health records. If you're using paper records, you don't have one. You're using Post-it notes, and be sure you don't stick Post-it notes with snide comments on that get left in the records. A task note is how in the EHR administrative comments are made from the front office to the back office, from somebody in the office to the physician. And those comments that I went over all were found in those kind of notes, and those are now open for the patient to see.
So in this case, I think part of the point is the physician might not think, or their staff, that this is part of the medical record, that it's just their internal communication. But in practice, those patients can get access to that. And so that's something they maybe want to communicate verbally, but not have in the medical record.
Right. And what I said is teach your staff and yourselves that
Yeah.
pretend that the patient is looking over your shoulder and reading everything that you enter in the medical record.
Great. I have 2 questions on chaperones. Are all genders of providers encouraged to have a chaperone no matter what?
Are all genders of chaperone? Well,
No, all genders of providers. So if a woman physician,
Yes,
I think,
yes,
is seeing a
yes.
woman patient and doing an exam.
right. Let me tell you that most physicians say, Kathleen, I'm a female and I only use a chaperone if I'm examining a male, and a male will say, I only get a chaperone if I'm examining a female, and I will tell you what I tell them. Well, we recommend at the doctor's company that you use a chaperone regardless of the gender, because we have more claims against same-sex doctor than opposite-sex doctor. So that's a myth.
That is a huge part, yes.
Yeah.
Nope, I think that's exactly what they wanted to hear, because I think that question comes from that same belief. Hi, for a male echovascular technician, do we need a chaperone? I have never seen this in any setting.
A male echo well, it depends on what they're
Vascular
doing.
technician.
The technician.
Yeah. I mean, I think the answer is the same judgment. If we're
Yes.
in a sensitive place, you should have a chaperone.
Yes. If you're in a sensitive place, if you're doing an echo on a male, and that's different than if you're a male technician doing it on a female and you're bearing the breasts, then I would have a chaperone for that person. And the chaperone does not have to be the same sex as the patient.
That is actually, I think, helpful and good to clear up. You're just having a second person in there to help be your evidence effectively,
Right.
be your witness. For nurse practitioners who we work with, and it comes up with PA as well, are we responsible for all the things they document? Or is it on their license? I.e., if I speak to my NP and make these recommendations for documentation, but they don't do it, does that fall on me?
I'm going to make a comment and then I'm going to have Rich comment. First of all, in California now, you're using, even though we have independent practice of NPs, we're not really seeing that yet in California. So right now, primarily, you are required to have a supervising physician for the nurse practitioner. And if you are the supervising physician and you give guidance, yes, you have an expectation that they follow your guidance. If they don't, that's a peer review issue that should be brought up in the group. So if they aren't doing it now, if the nurse practitioner comes to you and says, should I do this or do that? And you say, do this, and they do that instead. Rich, how's that going to play out?
I think it's an excellent question, because there's a cause of action in California under negligence that says that you as a supervising physician have responsibilities to make sure that you're properly credentialing people and monitoring what they do. And there can be something called vicarious liability. So if you're in a supervisory role and you're not properly supervising, or you're aware that somebody is doing these types of things on a regular basis, you can be held vicariously liable for what they did or failed to do. I think it's important to document. It's important to make sure that you have proper credentialing and that you do proper monitoring and periodically audit those evaluations, so that someone doesn't say at a later date, you failed to adequately supervise and therefore you are responsible. But as you'd indicated, Kathleen, that's a bit of a problem. And that's why it's important when you're supervising somebody to make sure that there's clear communication as to who is doing what, and that there's proper follow-up to make sure that what somebody said they were doing was in fact done.
I will tell you, typically.
And so in that case, Rich, well, I was going to say, just in a standard management of anything else, if you have that meeting, say, hey, you need to be doing this documentation, you need to make that note in either their employee file record, or even just, for me with the small staff, I send an email to myself. I had this conversation with this staff member, do it. You've at least created a paper trail record that you've had that discussion, and then in further follow-ups, if you find more of a problem, you need to follow up on that.
Perfectly stated, exactly right.
I wanted to add that if in what our experience with nurse practitioner and PAs is very low litigation rates. Their documentation is very good. When I do medical record review, I rarely have recommendations for the PA and NP documentation. And when we have litigation and the PA or NP is involved, typically we see the supervising physician is charged in the lawsuit. They often don't even name the PA or the NP. And I think that's an interesting phenomena. And right now, there is a requirement, there has been a requirement in California that you have to have approved protocols for your nurse practitioners, and the supervising physician is obligated to know what those are. And I bring that up because if you are supervising a nurse practitioner, that would be something you would be asked in a deposition. Were you familiar with this? And Rich and I do another program on understanding the risks for PAs, NPs, and supervising physicians. In fact, we did it last year for San Diego Medical Society, and it was very well attended. And many doctors sent me emails and said, I didn't realize that I had to know what those agreements were. And Rich, what happens if they got in a deposition and they're asked about the agreement and they say, I didn't know anything about it, I never saw it?
They're held to the standard that they should have known. And you had a slide earlier, Kathleen, that said ignorance of the record or of lab studies, no defense.
Thank you.
Okay.
Any other questions?
More are coming in. Yeah, we do. Any tips on how to document for providers who does telemedicine, specifically with patients and declining in-person patient visits between ER and office? So tips on documentation for telemedicine.
Well, tips on well, I'm going to give something and then I'm going to ask Rich to talk about using the refusal of care form. Many physicians are using telehealth, and that's good. There's going to be some changes for some specialties depending on what they prescribe coming up in May, but the documentation should be the same, comparable to what in-office documentation. There is no certain thing as telehealth documentation. Usually the staff member onboards the patient into the visit, and that is they will see if they can get vital signs, if they get, update meds, and they do the same things they do before you come in the room to see the patient. So your staff can do the onboarding. The documentation is the same. Many people you can't take the blood pressure, but I can look at my Fitbit watch and tell you that my pulse is 78, or I can say I did a wrist take of my blood pressure was 124/72, and I can tell you that, and it's a stated rate that you put. So those things should be documented. If somebody doesn't, and I'm seeing more doctors call and say the patient doesn't want to come back in the office, they only want to do telehealth. And there you're looking at what are you prescribing for them? What are you treating them for? You should see them at least once a year in person, maybe every 6 months, depending on what you're doing. But if they get their labs and you get the labs in and you're looking at it, you're going to document that you reviewed the labs, that you did things. So you can do a telehealth visit can cover what you would cover in the office. But if you need to do a physical examination, then you need to have them come in. Now, Rich, if they say, I'm not coming in, I don't want to come in, and something goes wrong and they die, and then the doctor gets sued because the doctor didn't see them, what would help the doctor get out of trouble in a litigation like that? What would they need?
It's always the question of what is required by the standard of care. In other words, what similarly trained practitioners have done under same or similar circumstances. And sometimes I've seen it in circumstances where you have a dermatologist where a patient will take a picture of a lesion and send it to the practitioner, but the quality of the image is so poor that the practitioner can't make any determination. Sometimes it's necessary for the practitioner to say, you need to come in for this reason, and the patient needs to be advised that for continued treatment by the practice, an in-office visit is necessary. It may be necessary under some circumstances to actually write the patient a letter. And I know that our patient safety department works with practices in attempting to tell patients, this is what we require you to do, and we expect you to come in so that the record is adequately documented. And you'd referenced that earlier about informed refusals. And as informed consent became something that was standard in the United States approximately in 1917, now informed refusal is becoming equally important. And I recently placed an article on our website having to do with informed refusal. Patient has to understand that that's one of the options, and if they're properly advised as to what they should be doing, but make an informed decision, knowing the potential consequences, that's entirely up to the patient based upon his or her own self-determination. But it's important that that be documented, because if it's not documented, the patient, or in the event of a wrongful death, the patient's family will conclude the patient was unaware that had he or she done this, a better outcome would have occurred.
Okay, let's see a few more here. If I use Epic Chat and discuss a patient with the nurse, but don't tag the patient in a secure chat message, can that still be pulled and used in a case?
Yes. When records are obtained by a subpoena, everything goes. All of the secure chat notes, everything goes. And the metadata. Now, let me tell you a story. When this law passed in October 6, 2022, that task notes were open in the portal, I had a doctor call and say, we have some really inappropriate notes in our tasks. I'm going to have my staff go in and wipe them out and delete them. And I said, don't do that. It's going to show in the record. And the patient was involved in a litigation, and they had gotten a subpoena, and it was Rich reviews our subpoenas, and I said it's an appropriate subpoena, and that's what he said. Well, I want to have our staff delete these inappropriate comments in the task notes. And I said, no, you can't do that, because when there's litigation, the defense attorney and the plaintiff attorney will request, they don't do it at the very beginning, they might be a year into the litigation, and they will request a copy of the metadata from the system, and they will reconcile everything that is in the record that they print out to the record in the metadata. Rich, do you want to comment on that?
No, I think you've covered that. You do not go in and delete anything, because that looks even worse. What may otherwise be a defensible case, suddenly now there's a question about the medical records. The medical records are considered valid and are independently admissible into evidence because they are a record made at or near the time of the event. And although there may be something that reads a little untoward because it's perhaps derogatory towards the patient or makes a flip comment, once you change the validity of the underlying medical record, suddenly the entire medical record is called into question, and the case is much more difficult to defend.
Can I provide copy and paste plan from specialist note into EHR? What about discharge plan notes?
Well, I'm going to comment on the clinical application of copying and pasting another physician's note. You would have to qualify it and say, note copied and pasted from Dr. Cahill's assessment of date. Then you could copy and paste, but you couldn't do it and just put it in there as though it was yours or without commenting that it was copied. You could just say, and I wouldn't even say copy and paste. I would say assessment note from Dr. Cahill on date from his assessment of patient provided below. Rich, what do you think about that?
Well, I think it's absolutely necessary to do that, because you can't validate what another practitioner saw or did or thought. You can certainly rely on it to the extent that it's a reasonable note, certainly within the community standard. But to take that as your own when in fact it's not, puts you in the dire circumstance of trying to defend what somebody else said or did.
I want to say something about copy and paste, because I know from reviewing records that physicians do it, because when I look in every visit has exactly verbatim the same thing, the same problem list, the same spelling error, everything. And I want to say, if you make a decision to copy and paste for this visit today, please personalize something in that note, because it will show. And it's so easy to see, and you don't need everything. And while I'm at it, I want to say about problem lists. nobody should have a problem list that has 97 problems on it. And I see that in medical record review. I see 50 problems. And they often, in some medical record systems, alphabetize them. So if I came to you today with a urinary tract infection and you treated me, the note would put that at the end of my problem list because urinary starts with a U. So the next doctor that sees me sees you have 10 problems for me, but are they going to look carefully at all 10? And you'd have to read the notes to know I came at the last visit for the UTI. So you want to be sure that you understand what your problem list looks like and clean those up. Delete problems once they're resolved. It's over.
Okay, we still have a few more and actually more coming in. So if you're okay with going, I'm going to try to burn through these.
Rich, I'm okay for staying on. Rich, are you able to stay on, Rich?
Yes, for a couple more minutes. I think we mentioned before, I start my day at 3 a.m. So the longer we go into the evening, it becomes a little more difficult.
If you need to go, Rich, that's okay. I could stay on because I didn't start my day at 3 a.m.
If our EMR gives patients a care summary automatically in the patient portal, do we have to ask them and then print out these? Our portal makes it clear that it's available in an email.
Well, this comes up all the time, and here's what I'm going to say. Yes, you should ask them if they want it. I think it's best to print it and give it to them because most people are not going to go look at the portal. I had a doctor's appointment recently, and my doctor said, you can see your history, you can see your summary in the portal. I said, I don't go in the portal. I'm on the computer all day long. That's the last thing I want to do. I'd like a copy at my visit. That's what I said. I think the doctor, if you ask the patient, the patient says, no, I don't want it, and then you write patient decline summary, it's a lot easier to just print it and give it to them. And if that's your habit and practice, people can't say, I didn't know what you told me to do. I didn't know it was a problem. I didn't know I was supposed to come back. And Rich, if you always give them that summary, which tells them what their follow-up is that to the advantage of the physician in the event of a litigation?
Yes, and it's the one practical exception to the rule, not recorded, not done, because under the California Evidence Code, you're able to rely on habit and practice to say, yes, this is how I ordinarily do things under these circumstances. And patients understand that, jurors understand that. They know because professionals are trained to take certain precautions and to follow certain rules. And if you ordinarily do that, even though maybe you didn't record it, that is very persuasive evidence, and jurors will rely on that to say, well, that's his or her general practice of doing things. There's no reason to believe it was not done here. The patient's claim that it wasn't done is not substantiated by anything, and therefore, I think tie goes to the physician in a circumstance like that.
I have a group that has a problem having their documentation done at the end of the visit to generate this clinical summary. And for that, what they do is they tell the patient the clinical summary will be available within 48 hours or 2 business days, because they don't do it on the weekend. Within 2 business days, would you like to see it in the portal, or do you want us to mail it to you? And it's about half and half. People say, mail it to me. And the other half say, I'll just look in the portal. And then I say, just have your MA, they made a drop down under clinical summary that says mail or patient will check portal. And they check that. So they have documentation at the visit, they ask the patient. But I think part of the reason sometimes people don't get the clinical summary is that the doctors, you're running from exam room to exam room, and the patient's going to be gone, and you don't have time to give it to them. And that's a different thing. But you can manage the expectations and say the summary, is going to be ready at the end of the day or within the next business day, and it will be in the portal. And would you like us to send it to you? Now, that's busy work for your staff and the cost of an envelope and a stamp. If you're using encrypted email, you could email it to them. And by the way, if patients use your portal to email, that's the best place for them to email you is through the portal, not from their personal computers and from their cell phones that aren't encrypted.
Okay, I have a quick follow-up to that. UC San Diego Health has patients sign a once-a-year document titled Terms and Conditions of Service, Admission, Medical Services Financial Agreement. Section 7 is for telehealth services and is linked to an informed consent. It says patient surrogate agrees to proceed with evaluation and, quote, holds us harmless, knowing those risks. Will this harmless clause hold up legally?
No. Number one, I think that it's an outstanding thing to have a conditions of treatment or service, or however you want to term it, to tell patient these are the rules of the roads. And if you don't do these, you may be subject to termination or discharge as a patient. Very important. And if you do have that type of a thing, it's probably worthwhile to mention it on your website to say, these are the terms and conditions of treatment by this practice. Hold harmless clause, not only is it not going to be valid, it's going to make jurors mad, judges mad, to think that you tried to say the responsibility is on the patient didn't do it, and therefore we wash our hands of the situation. It doesn't get you anywhere, it doesn't protect you, and it tends to work against your interest to say that somehow it's the responsibility of the patient. I think that hold harmless clauses are a major mistake.
Got it. This might be beyond our scope. As the public health emergency is ending in many states, is it now required for face-to-face visits for narcotic refills? What's the length between visits?
Well, that's something that I'm going to give some comment, because the federal public emergency is going to end May 11th. And right now, in fact, you have until March 31st to put a public comment for the Federal Register, DEA Federal Register proposal about issuing certain scheduled drugs through telehealth visits and not having visits. So that's all up for discussion. Right now, what the proposal is that after this would pass, which would be after the May 11th ends, the executive orders end, that a physician would have to see the patient in person to order scheduled drugs the first time. But because that can be a hardship for critical access in rural areas, and it's a particular issue for psychiatrists who have really pivoted to a huge telehealth marketplace, which has been very effective, and mental health is very important, patients don't come into an office at all. So what this proposal, there's another part of a proposal that says, if you can't see the patient, you could rely on an assessment by the primary care patient for that patient for a prescription. You still have to check the state. In California, it's the Cures Prescription Management Program, so you have to check that. That doesn't change, but it's uncertain. And I know I've been sending out to a lot of physicians, and if anybody wants the site for the public comment, if you send me an email, and my email address is on the last slide, kstillwell@thedoctors.com. I will send you that. The public comment ends on the 31st. I have some physicians that are for the proposal and some that are against. And of course, there's also we don't know yet what the final rule is going to be. California ended the executive emergency orders February 28th, but they're not addressing the prescribing on the telehealth.
If I type in the record while seeing a patient, some unedited notes to remember with typos, then I edit after the visit but before finalizing, is this okay? Is this being considered deleting or in the metadata, or
no,
not?
That's called editing. That's fine. It's like writing a letter and you do a draft and then you fix your draft. The goal is you want to do your note the same at the same day if possible, or within 24 hours.
Yeah.
If you can't get to it, or you have an emergency and get called away, and you're going to be over 24 hours, you just, the EHR timestamps when you did it, but you could put late entry. So you're not trying to pull anything over anybody's eyes, you know, delay. There could be a delay.
That's
the internet
exactly.
went
Your
down.
risk is if you do something after the fact and it looks like you're covering up.
Right. So just say it's a late entry, and if the internet went down or computer not available, I mean, there's a lot of reasons. If anyone is with the doctor's company and has any further questions, our 800 numbers here, you can call me anytime. You can send an email. And if any questions come in after, if you want to send them to me, Paul will be sure and respond to them.
Great. I'll try to grab the rest that we have here, and then I will thank everybody for joining us tonight, and remind you to complete your CME form in the next 5 days so that you get credit. It's right there. It's been up for a while. And please, if you're not a member of the Medical Society already, please consider joining and go to sdcms.org.